We have everybody we need. Do we have everybody we need?
This is Nancy Hungerford. I'm appearing by phone, but I don't know that I see the board.
What, are you scared of the fight?
We good? Okay.
Okay, I can now see you.
There we go. All right, so we will return into open session at 7:58. And make sure that I have this everything in place here. So I'm going to invite Nancy Hungerford, our attorney, to go through the process that we have here for the pre-termination hearing. And that way we're all on board with what's happening.
Okay, thank you very much. So this is the pre-dismissal hearing for a contract teacher. That is a teacher who has passed probationary period of 3 years. This procedure is dictated by ORS 342 805.934, particularly the portion that has to do with the fair dismissal process. For a contract teacher, there is no requirement of a pre-hearing conference, which you are having. Nevertheless, we provide that in order to provide due process rights for the teacher, the opportunity to express her position. This is a limited pre-dismissal hearing. The superintendent will start by outlining the reasons that were given in the written explanation and letter to the teacher. And that should take no more than about 5 minutes. I believe the board has been provided with a copy of that. Superintendent can add any remarks, and then it will be the teacher's opportunity to present any information she would like that would be pertinent to the question of whether or not she should be dismissed. And that should probably take about 10 minutes. And then there'd be an opportunity for the superintendent to add remarks in response to the teacher's remarks. The board would then have the opportunity to ask questions. Because we are having this in open session at the request of the teacher, and I'm assuming that is correct, that she has not changed her mind about that, we will be proceeding in open session. Then after there are opportunity for questions to be asked by the board and answered, the board will close the hearing. The board at that time needs a motion from one of the board members as to the disposition of the recommendation that's made by the superintendent, whether to support that recommendation or not. There's a second, then there can be discussion. And any member of the board may participate in the discussion at that point. There's no opportunity for participation from any members of the audience or from any of the parties unless questions are directed to them by the board members. Following that, when there is a call for the vote, the board members will each vote as to the resolution. So that's the process we have here tonight. Again, the basis for this dismissal for this teacher is neglect of duty and also insubordination. Those are two of the reasons that are listed in the statute as being the basis for the dismissal of a contract teacher. We have a preliminary hearing here before the board because under the law, this teacher would have, if dismissed, an opportunity to go before a fair dismissal board, which is a board of appointees by the governor. There are people who would not be citizens of the district itself. There would be a teacher, a board member, and a member of the public on that panel, and that would be the post-termination full hearing that the teacher would be entitled to. So at this time, if there are any questions, I'd be glad to answer those.
Any questions on the process?
Is there any requirement for progressive discipline in this?
In this particular case, there is no requirement in the law for progressive discipline. Your contractual agreement does not apply any kind of just cause or provisions there, because this is a statutory hearing and the contract so provides. In terms of progressive discipline, generally speaking, that's appropriate when we're talking about a inadequate performance kind of case, where there have been multiple opportunities to improve performance or comply over a period of time. In this case, because the charge is insubordination as well as neglect of duty, it is because of the requirement that there be a single reason here given as to why this teacher is not willing to comply with the directions of the governor as well as the superintendent. And it is not one of those situations that really lends itself to progressive discipline, because the time has already come and passed when governor has stated that there should be compliance, either vaccination or that an individual who has an exemption under either religion or under a medical condition may be allowed to continue teaching if there are appropriate precautions that are provided, which generally are set out to be testing on a weekly basis, KN95 or N95 masks, and exclusion from some areas where there would be unmasked individuals who would be eating or drinking. Those are the usual precautions that are taken. So those are the requirements under the statute. The superintendent is compelled to comply with those.
Any other questions about the procedure? All right, hearing none. I will just make sure that we're all clear on this. You do want this in open session, correct? Okay. I just want to make sure that I've got that from you, not from somebody else, that we have a misunderstanding. So, all right. So I will begin the pre-termination hearing then, and I will turn it over to Superintendent Riggs to start it out with the letter recommending dismissal.
Thank you, Board. I'm reading from an October 19th, 2021 letter to Tina Tressel regarding a 20-day termination notice. The letter is stated, "Dear Ms. Tressel, this letter notifies you that I'm providing you with a 20-day notice of my intent to recommend that the school board terminate your employment with the district. I intend to make this recommendation to the school board on Monday, November 8th, 2021. If you'd like an opportunity to meet with me before I make the recommendation to the board, please notify me by Monday, November 1st. The statutory basis for this recommendation is as follows. Insubordination, ORS 342.8651C. Neglect of duty, including duties specified by written rule, ORS 342.86. District staff members have tried to give opportunities so I do not have to make a termination recommendation. Holly Elementary School Principal Josh Dargis has had multiple conversations with you during September and October of 2021 regarding how you must either be fully vaccinated or provide documentation of a medical or religious exception in order to comply with Oregon Administrative Rule 333-019-1030 in order to teach, work, or assist at school after October 18th, 2021. Mr. Dargis also provided you with the medical and religious exception request forms to complete. None of those, you have not turned in any of the documentation that was requested. The Business Office Secretary, Jennifer Maynard, also reached out to you to see if you may have an OFLA or FMLA qualifying leave. You have not provided documentation to support such leave. Business Manager Kevin Strong called on October 18th, 2021, to see if you prefer to take an unpaid leave. You decline. If I make a recommendation to terminate your contract, the school board will take action on this recommendation at the board meeting of November 8th, 2021, at which time you are entitled to a hearing. If you elect a hearing, it will be conducted in executive session pursuant to our ORS 192.6602B, unless you elect to have the hearing conducted in open session. If you elect to have a hearing, please notify Julie Emmert on or before November 1st. The end is, sorry, I might not have the end of the letter, but basically it's if the school board votes to terminate your contract, your employment with the district will end immediately upon the vote of the board. Beginning today, October 19th, 2021, from the letter, you will be paid on paid administrative leave. You may not be present in the workplace for any reason. However, the district may assign you work to do from home. If you have any questions about this process, please do not hesitate to contact me. Sincerely, Lisa Riggs, Superintendent of Sweet Home School District.
Is that everything you had?
That is the letter. And I believe that further because made, we did speak by phone. I have that, and so, Strong, our Director of Finance, myself, and one last attempt also that I do want to say maybe now and at the end of our discussions are that we out to Ms. Tressel to say if there is not a willingness to turn in an exception for medical or religious reasons, will you be make the accommodations that others are making? We did not hear back to that decision to move forward with any accommodations as well.
Okay. I'll open it up to you then, Mrs. Tressel. Yes. No, that's a different. We avoided the executive session for the first part because she wanted this to be in open session. So this is taking the place of the 2B. So sorry. All right, Ms. Tressel, I'll open it up to you.
Great. Good evening, members of the board. My name is Aruna Masi. I represent Ms. Tressel through the Sweet Home Education Association. And I want to start out tonight by reading to you a letter of recommendation written for Ms. Tressel by former Superintendent Tom Yares. He wrote, Ms. Tressel has worked for the Sweet Home School District for over 20 years. She began as a volunteer working in the classroom, which led her into a temporary position as a classified employee. Due to her great work ethic and skills working with students, her temporary position turned into a permanent assistant position. Ms. Tressel then went back to school to get her speech certificate and worked in our student services department for 6 years while completing her bachelor's degree. She later completed her elementary special education certification and has been working in the district as a special education teacher, and that's since August of 2016. He also noted in this letter that she is a great asset to our school district. Today, we received copies of the personnel file for Ms. Tressel. If you have an opportunity to review those records, you will see that her evaluation forms indicate that she is determined by her supervisors to be proficient or exemplary in almost all of her evaluations. And I will let Ms. Tressel come forward and share with you additional information that she would like to share with you with regard to the facts. I apologize. It's difficult to hear for those of us who are online.
Is it on? Should be.
Is the mic not functioning?
Oh, okay, it wasn't on. Okay, so can you hear me now, Aruna?
Yes, we can. Thank you.
Okay, thank you. Okay, I just want to start out by saying thank you to all of you guys for stepping up to be part of the school board and wanting what is best for our community, staff, and students. That's why I chose to work with children as well. Your time doesn't go unnoticed, and I truly do appreciate all that you do. I just wish that, you would consider what I'm going through right now. If you add up all the years I've been involved with the district, starting out volunteering, subbing, being a temp, permanent assistant, a speech and language pathologist assistant, and at the moment, a special ed teacher, I believe that adds up to, over 20 years. Before the district, I went to college and was working as an accounting clerk, and I loved my job. My goal was to become a certified public accountant. But my life changed when my daughters were in a car accident, and that changed my career. Because caring for them at home and taking them to school made me feel like I needed to be in the school with them, and that changed my life. And I know that I have the patience to make a difference in a lot of children's lives. All I wanted to do was take FMLA due to my personal health issues and also the work-related stress that I've been going through, because I wasn't even getting enough support. And I don't even feel like I was getting the response to even some of my emails or get the extra support with all the concerns that I had. My doctor knows me and wouldn't have written a doctor's note if he didn't think I didn't need to do this. And then you add COVID and the accommodations, and now I'm going to lose my job, my students, my coworker friends, my retirement, my paycheck, my insurance, my livelihood. That being said, as far as the exception forms and the accommodations, I did fill one out and I was wearing a mask, but my conscience just would not let me turn that form in. My whole body, mind, and soul screamed at me and told me that this isn't right. And as far as the accommodations, I cannot even wear an even thicker mask than what I was wearing, and then wear a shield on top of that. Then you add this testing that's not even proven to be very accurate between the flu and COVID. I also fear sticking something up my nose every week. That also isn't very accurate. And then you have that, app to put on the phones, and also taking the time to sit down and write down everyone I'm around and be tracked and traced. I'm already overwhelmed with my job as it is. And that hasn't even been taken seriously. I feel this goes against my medical freedoms, against the Constitution, and it's unlawful. There are hundreds and thousands of scientists, lawyers, doctors, nurses, journalists, and other intelligent people trying to reach out and share facts because they know their science. And there are many people ignoring this. These intelligent people are being shamed, criticized, and quieted and are fired. And some are just accepting the following narrative. Some are being coerced, and some are just quietly quitting and leaving their careers because they know things are not right. This really puts red flags up for me. All this is over something that has a 99% recovery rate. And this shot is not guaranteed to prevent you from even getting COVID or prevent the spread of it, as we can all see. And as of yesterday, even the federal government suspended the vaccine mandate, if you guys haven't seen that. I just want you all to know that COVID has affected my home, my family, my daughters, my friends, and God only knows who else. Because I feel that the media isn't giving us true numbers or accurate information. In my family, we've dealt with the mild flu-like symptoms, which have been around for hundreds of years, and we take care of it. However, I've also seen firsthand how extreme it can be. My oldest brother was with underlying conditions and not so great life choices, was put on a ventilator. And it was very scary. And by the grace of God, he is alive, and it's changed his life, and now he has to deal with it. I really get it. I get it. I know there's something out there that's hurting people, and it's very evident. But what I don't believe is that this shot has more benefits than risks. And I completely understand that some people feel strongly opposite of what I believe, but that's okay. It doesn't bother me because that's our rights. But this experimental shot should not be pushed. And the people that don't take the shot should not be discriminated against by wearing a different mask, wearing a shield, taking tests, and having someone track them. I don't agree with this because it's unlawful and it goes against our Constitution, our Bill of Rights, and our sovereignty. If others want the shot, then they should be able to get it. But if you don't, you shouldn't be made to. And what I do know is that my unalienable rights are being violated, and my whole body, heart, and soul is telling me that this isn't right. And I should not have to be forced to follow this narrative, because next they're coming after our children next. And I don't want any part of this. I don't want to be a part of being in a school and seeing kids get sicker because of some shot that's not working for kids or people. There are countries in many states that are not following any of these insane narratives, even third world countries. And they are doing okay because their doctors are giving them life-saving medication that has been around for years and even sold over the counter by proven science with no side effects. All of this just keeps rolling around in my head, and I keep asking myself and researching why there are so many people exempt from such a deadly virus. I feel it's very clear, and if we, the American people, can't come to some conclusion that there are people out there that are very evil, then there is something very wrong here. So here's my opinion and my final note on this. I believe there are many others that feel the same way, but they're afraid to speak up. I believe that COVID is not a true virus, and that this is my honest opinion. When you have gain of function and a so-called virus that has been patented over 70 times, this is not considered a true virus. And as far as the shot, I do not believe it is a proven vaccination, and it has not been studied or proven to help people, as I am seeing firsthand in our community, in my family. It's hurting them. People I know are getting COVID more now than before they received the shot and are having adverse side effects. I sent all of you documents with the ingredients that I have heard of in these shots, and I hope you all reviewed that and reviewed those documents, because that's how I feel. I'm not a scientist, I'm not a doctor, but I do know what some of the ingredients are, and they will never be put into my body voluntarily. I do not consider this a vaccine. I know my body, and these ingredients would put me more at risk than protect me. And I think we need to start listening to the thousands of intelligent Americans that have many years of knowledge in this field and join other states that say no to all this before they inoculate any more of our precious innocent children and adults all over the world. Under the Oregon law, there are a number of grounds that are unlawful. Number one, Oregon 433.416, in requiring immunization as a condition of employment. Number two, it violates Article 1, Section 22 of the Oregon Constitution, as well as Article 3, separation of power principles. And three, it violates the rights of free expression guaranteed in Article 1, Section 8 of the Oregon Constitution. And number four, it violates the equal privileges of immunities guaranteed of Article 1, Section 20 of the Oregon Constitution. And it amounts to wrongfully discharged from employment. And depending on the outcome of this board hearing, I am going to seek further legal advice because my mental state of mind cannot follow this narrative any longer. And I do feel like I should be staying on paid administrative leave instead of seeking legal advice until the board can prove to me that I've broken any laws and that you can give me answers to the documents that I gave you and then I forwarded to you all. And that concludes my thoughts.
Thank you. Turn it back over to you, Superintendent Riggs.
Thank you. Thank you for sharing your thoughts. It's probably the most that I've heard from you directly, and wanted to clarify one thing that I heard you say is that did you say continue to stay on unpaid or paid leave? What I didn't hear, sorry,
I
what
feel
you
like
said.
until they can prove that I've done something wrong and this is lawful, I feel like I need to have answers. I didn't receive anything back from the documents that I sent the district explaining these questions that I had, along with many more people that I know have asked these questions and they can't answer them.
Mhm. So the reason why I ask is because in this process, first of all, I can speak for myself, and I certainly know that after you spoke, it's an uncomfortable place to be in. It's not where we want to be. It's not what the district is looking forward to, and it's certainly not something that I'd like to bring to the board. What I feel in this situation is that in our contact with you through our principal, through Kevin, myself, we are trying to work on how we can keep you employed with Sweet Home School District. And so many various options have come out. And so just to recap that, granted, there were dates in which district employees needed to provide us their documentation of the vaccination. If that's not something, then the exceptions, both medical and religious, were also given and granted through our processes. And so coming to you and saying, are the accommodations something that you're able to do, is really just absolutely important to know, because our intent is to not only follow this process, but do whatever we can to keep you lawfully employed. Also, you brought up the FMLA, and the guidelines that we need to follow is to ask for the minimum amount of paperwork. And it's more than just a note, and we have the documentations and of course shared that with the board and to you, the amount in which to be able to move forward with that leave. Again, hoping that that was something that would support your needs and continue our employment with our district. Also, offering to go on unpaid leave, which means that you are an employee of the school district, was something that was offered, again, extended so we could keep your employment with Sweet Home. So I too come to the board tonight to say these are the things that we put in place lawfully, the procedures being followed, the policy being followed, making sure that the process was done to support and make sure that you were well taken care of and also as the district being taken care of. There's not much more I can do except come to this hearing in this situation without knowing if unpaid leave or FMLA or other means of continuing our employment could be something that we could come to terms with. Without that, then I need to submit to the board this 20-day pre-termination hearing. Again, so I'm going to just ask, is there any of the number of things that we've brought to your attention that you need help or support to move forward with, other than the recommendation for termination?
No, you've heard me out. You know how I feel. It's wrong. What's going on in the world right now is wrong. And I'm sorry that you have to be the ones that have to make that determination, because I know it's way above me. I know it's way above the school district, above our state. But this is wrong. And I'm going to stand with that. Not okay.
Okay, I will open it up to the board for any questions that you might have for Mrs. Trussell.
I need to completely understand why the religious exemption is not an option for you.
I had it in there. I had it in my paper, but I took it out because I feel like it's like a train ticket. And if you know history, you should know what that means. I just don't feel like it's right. I don't feel like my name should be on a list, or anybody else's should be on a list of why does religion have to be a part of this? I am religious, and you know me, Mike. I am very religious. And I had one filled out, and I could not turn that in because I know it's not right. Nobody has that right to know how I know that.
Any other questions?
Ernie?
Of our
Can
attorney?
can the board ask Nancy questions?
Nancy, can we ask you questions regarding this?
Yes, you may.
I guess, Nancy, my question would be, what if the board was to deny this request of dismissal, what's the fallout, if you will, on the district, for not agreeing to terminate?
Well, the OAR, the administrative rule that the superintendent cited, says that after October 18th, 2021, teachers, school staff, and volunteers may not teach, work, learn, study, assist, observe, or volunteer at school unless they are either fully vaccinated or have provided documentation of a medical or religious exception. With the religious exception, which I understand dozens of your employees have asked for and have been granted, then they may work in the schools, but they do have the requirement that there be extra masking and testing to keep children safe and to keep other staff members safe. So the religious exemption is an option. Maybe even a physical exemption or a medical exemption would be an option, but this employee would have to accept those additional safety precautions. Other than that, and if she rejects an unpaid leave, the only option for the board is to pay her for doing nothing because she cannot be in school. And that's by the governor's order and by the order of the Oregon Health Department with this OAR. So I think that the other thing to be kept in mind is that you have many employees who have similar questions, quandaries, objections to this mandate. They have accepted the obligation with either religious or medical exemption. They've accepted the obligation to do these safety precautions so that we will not have children who are put in harm's way or other staff members. I would also point out that you have liability insurance coverage when you have someone in your school who is found to have contracted COVID at school, let's say from an unvaccinated child, because children have not been able to be vaccinated until recently. But if you knowingly allow someone, an adult, to be in your school working with children, and they will not take the safety precautions that are required, then your liability coverage is in doubt. And so that is, one of the things that your liability insurance coverage demands is that you follow the rules of the state. So as I said, unless you're prepared to pay her for doing nothing, because the school does not operate any remote instruction, the school has, as I understand it, contracted services for children who need remote instruction, but they do not provide that with their own teachers. But before you take any action regarding this employee, I would ask you to think about your entire employee group who have accepted the masking requirement, the testing requirement, in order that they can come to work and that they can earn a living. And I would suspect that you might have many more who would say that if this employee is allowed to draw a salary without doing work or without complying with those safety precautions, why should they not be given the equal protection? I understand that you have 100 or more employees who have taken one of the exceptions and have agreed to work with those safety precautions.
Nancy, there's nothing in that OAR that says they have to be terminated though, correct? Those words aren't in it?
Right. It doesn't say they have to be terminated. It just simply says that they may not teach at school unless they're fully vaccinated or provided documentation of a medical or religious exception. But this employee is not just asking for you to continue her employment, which would continue her retirement status and so forth. She's asking to be paid for at the same time, but you cannot use her in the schools to provide educational services.
But she could be reassigned to a different job title that wouldn't involve teaching or being around students.
She cannot work in the schools, so I'm not sure that there would be any job titles that she would qualify for. For instance, our custodians must follow those requirements. Our food service individuals must follow those requirements. Our instructional assistants must follow those requirements. Our bus drivers must follow those requirements. So all of those categories of employees also are subject to these employment requirements. And they have complied, even though they may have asked for an exception. The law allows them to come to school and work because they're willing to perform the safety and follow the safety precautions. If this employee were to tell you that she is willing to follow those safety precautions, the school could have her back working.
Any other questions? I do have one for you, Tina. I know the type of teacher you are, and you're exactly the type of teacher that Sweet Home School District wants and needs. It is in our best interest to do everything that we can to keep you here. Believe me when I say that. This is nobody in this room asking you to get a shot. Nobody in this room asking you to do anything that violates you. As a matter of fact, I think a lot of us have a strong opinion against that. But we've talked about the OARs, and unfortunately, the Oregon Supreme Court and the legislature have both shirked their responsibility in taking responsibility in place of the governor in this situation. So that OAR stands with the force of law behind it, unfortunately. My question is, with a termination, you lose years of service, retirement, all of that stuff. If you could go on to even an unpaid administrative leave, you have the option of working another job in the meantime. My fear is that we get a month or two down the road, and due to the litigation that's out there, all of this changes, and we've lost an excellent teacher. We've lost somebody who is valuable to the kids in this district, and I don't want to see that happen. So I guess my question, I'm asking you if we can make that happen, if we can make the at the very least the unpaid leave happen. Unfortunately, you're talking about a lot of your future, and I understand the stand. But at the same time, I want to make sure that we're doing what we can to support you in this until there's no other choice that we have. So I don't want to go down this road.
Are you suggesting like a leave of absence, Jason?
Yeah, an unpaid leave of absence. It would be no different than, honestly, a termination to you, except you would keep all of those things that you worked for, the retirement and all of that stuff.
Members of the board, let me clarify a couple of things. One, if she were to be dismissed or go on a leave of absence, she could be rehired if she were dismissed when the vaccine requirement went away, or the testing requirement, or the other aspects that she's objecting to. But she would, if rehired or brought back from unpaid leave, she would not lose any credit for experience. She will still be placed on the salary schedule at the exact same spot she is now. Also, she would not lose her retirement benefits. Those benefits are built up over a career, and they would still remain in place for her as of where she stands right now. And if she were to come back and work for you after the vaccination requirement is over, or the masking requirement, or whatever, she would then begin building up again on her retirement benefits. So those are parts that either dismissal or an unpaid leave would not change.
Can I speak? But what else, I mean, the whole point, the accommodations, I'm not okay with them. I'm not okay with, if I waited 6 months and I came back, I'm still gonna have to do that same thing. So I'm declining. I don't, there are other states that are not doing this. They're not following this. I don't understand why Oregon is. I mean, I get where you guys are, you're following what they're telling you, but it's way above us. I know, I get that, but there are other states that are not following this. I don't understand.
That's true. And those states have governors who have not mandated what our governor has mandated. That's the difference. And if our governor would lift the mandate, we would lift it. I mean, I know that's how I would vote personally. So our hands are tied, like Jason said, by the law, because right at this point, the governor's executive orders are law.
I would point out that the mandate is in force until February 22nd. At that time, the governor may extend that mandate, but at this time, that's the only length of time. So if this teacher were to take an unpaid leave until February 22nd, then the situation would be reassessed. If it were extended till the end of the school year, then there could be an additional period of unpaid leave till the end of the school year. I think that the chances of a mandate being lifted before the next school year are certainly dependent upon what the status of the COVID infection is. But I guess there's a good chance that there would be a reconsideration of it by that point in time.
Right. Any other questions?
Mm-mm. No.
Okay, hearing none, I will close the pre-termination hearing and we will move into the decision-making process. So at this point, I would invite a motion to be made regarding the superintendent's recommendation.
Mr. Chair, I believe I have a conflict of interest,
Okay,
so I have to declare that.
In what way?
As a potential problem with my wife being the president of OSEA and her having to defend this. Or just wanted to bring a potential conflict of interest up and bring it up to you, Nancy.
Can you explain that to me a little bit more?
My wife is president of OSEA, Oregon School Board, or Oregon Employees Association, which yeah.
I don't know that that presents a conflict for you under the law. Certainly, I understand where that may put you in a difficult position. However, that is the presidency of the association that represents the classified employees, and I understand this employee is a member of the other association.
Yes, but it's a potential. That's why I brought it up as a potential conflict.
Mm-hmm. Yep. So I do not believe you have a conflict.
not hearing any motion. I'll just let it go again if we have a motion.
Can I ask you one more time, Ms. Tressel, would you please consider an administrative leave?
I decline, because if I come back, I'm still going to be facing the same thing, and that's just putting me under more
Not
distress.
necessarily, not if the mandate gets lifted.
Decline. I can't handle any more of this. I don't want to be part of something that's going to hurt kids, because that's what's coming next. I can't do it.
I might suggest one other alternative for the board, and that would be to dismiss this teacher at this time, but to reemploy her at such time as the vaccine mandate is lifted.
Our hands are tied, right?
we shouldn't be discussing unless we have a motion to discuss. So I'll ask one more time. I'm not hearing any motions, but I'll open it up one more time just so that everything is clear. Do we have a motion to regarding the superintendent's recommendation?
Jason,
Yes.
I would make a motion to go against the superintendent's recommendation.
Okay, we have a motion to reject the superintendent's recommendation. We have a second.
Put a second, another motion out there.
I do not hear a second at this point.
Jason,
Okay, so we got Kevin Hill seconding that one. So now we can go into discussion regarding the motion.
I wouldn't do that only because of the liability issues that puts us under.
Doesn't mean we have to put her back in the school or in a classroom, just not terminate.
Not terminate, but continue to pay.
Well, I would imagine that's something that we would have to discuss. But if she's not working, she's not going to get paid, I wouldn't imagine.
Except that there's a contract there that says that she would. I'm assuming that's correct, right, Nancy? There's a contract there that would require payment.
That is correct. The board cannot just unilaterally place her on unpaid leave unless it's for some disciplinary reason, which there really isn't one here. In terms of short-term unpaid leaves are generally provided as disciplinary reasons. I don't think we have that situation here. So if you put her on unpaid leave, it would be tantamount to dismissal.
Okay, any other discussion or questions?
So if we put her on unpaid leave, does she have to agree to that?
Yes.
She said she would.
Any other questions for Nancy? Okay, hearing none, I will put it to a vote. So the motion is to reject the superintendent's recommendation. All in favor?
Aye.
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 Okay, and all opposed?
Aye.
Aye. Okay, so the motion fails.
I would make a motion that we accept the superintendent's recommendation.
Okay, we have a motion and a second. Any discussion regarding this motion?
This paper seems clear. The motion needs to be very specific.
Ah,
Okay,
okay. I move that we accept the superintendent's recommendation to dismiss contract teacher Tina Tressel effective immediately for neglect of duty and insubordination.
okay, so we have a motion and a second. Any discussion or further questions for Nancy?
I'm sorry, but online we can't hear that. Thank you.
Nancy, can we accept or can we change the motion or amend the motion to accept back or to hire back if the mandate is lifted?
I'm sorry, I wasn't able to hear that. You're saying, can you have a motion to accept the superintendent's recommendation to dismiss and what? Can somebody repeat that to me?
To hire, and then to hire back, once the mandate is lifted.
Yes, the superintendent, the board could vote on that motion. You can have an amendment. I think under Robert's Rules of Order, there needs to be approval of the amendment first and then vote on the amended portion.
Thank you.
Okay, I'd like to amend the motion.
Actually, you
Oh.
made an amendment, there needs to be a second on that amendment.
Ah, got you.
You have to vote on her, on the.
No, we vote on the amendment. Correct.
No.
You want to clarify this for procedure here? Do we vote on the initial motion and then go back for another motion, or do we vote in the amendment, or what are we doing here?
Well, you can vote on the amendment. And I think that's what you should do, is to vote on whether or not the amendment will be added. If that motion goes down, then you would vote on the original motion.
I like to amend the motion, original motion to hire back, Tina Trussell once the mandate is lifted.
Second.
Okay, so we have an amendment to the motion to hire back Tina Trussell once the mandate is lifted, and a second on that. Any discussion regarding that?
My
Mike.
time.
This
Sorry.
is just for the amended portion of Ms. Brown's.
Yes, that's correct. Just voting on whether to amend the motion.
And then we're going to make a new motion with the amendment
Yes.
on it.
Exactly.
Correct.
Okay.
Right.
Thank you for clarifying.
Okay, any discussion? Hearing none, the motion is to amend the motion previously made to dismiss with the hiring back after the mandates are lifted. So all in favor?
Aye.
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 And opposed?
I'll redo it. Okay, as amended.
So should,
No.
should.
I'll
should
read
you
it all back.
The whole thing.
Here's
with
the
the
go ahead, back
amendment,
through the
I
whole
think?
thing.
So I would like to make a motion to accept the superintendent's recommendation to dismiss contract teacher Tina Trussell effective immediately for neglect of duty and insubordination, but we would rehire her should the mandates be lifted.
Was that a second deal?
Yeah.
Okay. Okay, so we have a motion and a second. Any discussion on the motion as it sits, or any questions for Nancy? Okay, hearing none, the motion is to dismiss and hire back when mandates are lifted. All in favor?
Aye.
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 And all opposed?
Aye.
Aye.
All right, motion passes.
Sorry, Tina.
I believe that concludes this section. So were we going to, thank you very much for coming tonight. I appreciate it. Appreciate you. Yeah, we are.
So I think Nancy said that there was another level that you go to, or you can go to. Can you explain that again, Nancy, the next level that she can go to?
Okay, I did not hear that.
Okay. Jim was just asking if you could explain the next level of appeal in this situation.
Yes, within 10 days, this teacher needs to file with the Fair Dismissal Appeals Board and ask for a hearing regarding this decision. And that will then be scheduled. The Fair Dismissal Appeals Board will appoint a panel of 3 people. The matter will be scheduled when it can be, and that depends on availability of counsel, availability of those 3 individuals, and availability of a person who advises them, who is an assistant attorney general. And so that hearing would be scheduled. Then there's opportunity for post-hearing briefs, and a decision then is rendered by the board after they have an opportunity to review those briefs.
Okay, that answer your question, Jim?
Yeah, did you understand that?
Thank you. All right, so are we going to enter into executive session, this other one that we have in place here?
You have a Zoom link for that?
No, we were just gonna control on that through the process. So,
Unless you have one posted for some other purpose as part of your agenda, you cannot go into executive session.
we were looking at 192.6602H.
Oh, okay.
And looking for guidance on open meetings and things around that. So I'm to clarify, would that qualify?
Without knowing a little bit more about that, I can't say whether that would qualify or not. Can you read 1H to me, because I don't have it here at the current time?
What was that again?
Can you read 1H, 192.660.1H? Does anybody have that part of the statute?
I'm pulling it up right now.
Okay.
H is to consult with counsel concerning the legal rights and duties of a public body with regard to current litigation or litigation likely to be filed.
And that was posted as part of the agenda tonight?
Yes.
Okay. Then you may go into executive session for that purpose. I will need to listen to what the question is before I can actually answer your question. But
Okay.
we can go into executive session for you to answer that, ask me that question, and I'll answer it there.
Okay. Sounds good. So we will recess the open meeting at 9 o'clock. And we'll need a few minutes to make sure that we've got Zoom ready to go and everything there. So just give us a couple minutes here, Nancy.